I just love when things we've said here show up in filings later. It tells me that we're on the right track. I've long said that 47.1 is unconstitutional. I've had conversations with Omar, the tilted lawyer, and he agrees. Today we're going to dive deeper into why that is, but in their latest filing, Queen Ellyn also covers why she feels it's unconstitutional, along with all the other ways that Blake's case fails. Something else we've covered here a lot. Draco is known as the first legislator of Athens in ancient Greece. He replaced the system of oral law with what's called the draconian constitution in 621 BC. It was a written code that was to be enforced by a court of law. There is very little left of his laws, except for an inscription found from 200 years later, referring to the law of Draco about homicide. What's told about Draco in his constitution is that it was very harsh. Excessively, you could even say unreasonably harsh, with the death penalty for most offenses. Because of its harshness, it was repealed by a magistrate in 594 BC, with the only law left in place that was his being his law on homicide. Since then, when laws or rules are described as excessively severe or harsh, they're referred to as draconian. And so she opens up her beautiful filing by referring to 47.1 as draconian relief. And I wholeheartedly agree. The intent of the law may have come from a good place, but as it stands before us today, and as I understand, they're attempting to write it into multiple states' laws as we speak. It is indeed draconian. I've long said that it needs a caveat where the first required step is a full-fledged investigation into the claims to ensure that they are legitimate. My belief in this was strengthened when Omar told us how often this happens in family law, which is his practice. He said he's seen lots of situations where the ex-wife or soon-to-be ex-wife will make these very same types of accusations simply to have the law on their side better. He told us it's used as a weapon for custody and for support. That makes this kind of protection frightening. It basically seeks to stomp out any attempts to defend yourself when you're accused of this type of harassment, whether you're guilty or not. Ellyn spends the introduction outlining what this motion is going to argue, and they're all excellent points. So moving on to the second point, which is another one I've spoken of multiple times here for a while now, those California statutes and codes that Blake has brought her causes of action on. I want to reiterate and better explain what I meant when I said that New York will not apply another state's code in their federal court. Yes, there are cases where they've said they're applying California statutes and codes. They did in this case. But when did they do that? When granting motions to dismiss. This is the place you will find California law most often in New York federal courts, when they're being dismissed. When I made those statements, I was speaking specifically in terms of coming to fruition, coming all the way to trial and being given as jury instructions for the jury to rule according to another state's laws. It's one thing to give lip service when you're dismissing a case anyway, but to legitimately take another state's law and provide it to the jury with instructions is a whole other matter that I could not find in the Southern District of New York. If you find one, let me know, because I am really curious to see if it ever has happened. But torts like false light or anything that's similar to defamation are never recognized in New York. They only apply defamation standards to such causes of action, no matter how you frame them. Now, one of the things she's going to do in this filing is to talk about the wording of 47.1. Another point that I've said since we first heard of it. Too many people read it as some magical, all-powerful kryptonite, and they gloss over the qualifiers that are in the language of this law. Qualifiers like without malice and reasonable basis. These aren't simple expressions. These have legal definitions. We've actually covered these strict meanings previously, and as she says here, that this actually doesn't turn to the Wayfarer parties, but it turns to Blake's motive and intent. That's what needs to be looked into. Whether or not she asserted these claims without malice and with a reasonable basis. And something we're going to cover a lot, that factual issues remain. Now, the footnote for this paragraph is very interesting indeed. We have some redacted information here from a 2-minute section of the deposition of Justin's former WME agent. This is sealed for now, so we don't get to read his testimony, but this is no doubt something very important that she's included here. As we know, Ryan is accused of approaching WME executives, demanding that they release Justin and calling him an S-predator. So far, Wayfarer's legal team has played very cool about what evidence they have and what sort of approach they're going to take in this case. They've released only small suggestions about what they might have, but this could turn out to be quite a bombshell if they're including it here. Because here they're talking about Blake's motives for her accusations, and these depositions seem to have something to do with the factual issues that remain to be tried in the main case. Now in Section 2, we're going to get into these constitutional concerns. They involve mainly the First and Fourth Amendments, but we are going to talk about other amendments that are involved. And also that pesky jurisdictional issue where she's not a resident of California and her allegations point to New Jersey where filming took place. This is another thing we've talked about quite a bit here, about this jurisdiction and how FEHA and California Civil Code could possibly apply to this case. And now we come back to the third footnote here, where it tells us that 47.1, it's been 2 years since it was accepted and 1 year and 9 months since it took effect, but there has not been one single published judicial decision that has addressed it. And that means that Judge Lyman's decision will be what's called first impression. Now, this is also a legal term with a very specific definition. It's a new legal issue without precedent or controlling case law. Now, we've talked about this process before, that judges don't just rule willy-nilly, but they follow established case law, especially from higher courts like courts of appeals and the Supreme Court. In this case, this is a California state law that hasn't even been applied in California yet. This leaves Judge Lyman flying blind. And that's the reason that many of us who report on this case do not believe that Judge Lyman wants to take this on. Because if the first ruling comes from him as a first impression, he will be the one creating a precedent in New York federal court for a California state law. And we're going to go through some of the reasons why he might not want to be the one who does this. But again, I want to stress that it's really odd that no one in California has made any decisions on this yet. Because this is a complex federal case involving multiple defendants, multiple moving parts, and it was consolidated from multiple separate lawsuits, we have what's called a consolidated complaint. This is done to make sure there are consistent rulings in a case. If there are any related cases, they are typically brought together like we saw happen here. But consolidated complaints complicate things. So this isn't even one typical harassment case. There's a lot of other moving parts, giving another reason why this isn't the appropriate case to give the first impression. She mentions factual findings again, and we'll hear that repeated throughout this filing because it's so important. The actual law states that in order for 47.1 to be used as a remedy, the plaintiff cannot have asserted their claims with malice. How do you prove whether or not someone was motivated by malice? We may have an opinion of why we think that's so, but to be able to prove it beyond doubt, I don't think we can do that at this point. We can't really do that without factual determinations. Who makes these factual determinations? Typically a jury. They can be decided on summary judgment, but in either case, these determinations must be made on admissible evidence. We don't have any evidence right now. We may loosely refer to things as evidence, but they are not officially evidence at this point. At this point, everything is just discovery. So whether it's 80,000 documents or 5 years worth of film, if you're Team Blake Lively and you don't know how to count things, or it could be depositions, but not everything they're collecting right now will be deemed as actual admissible evidence. So even making the determination right now is too soon. Once they go through all of their discovery, they decide what they're going to use to build their case. They can knock each other's evidence down through motions in limine, which we'll find out about later, but in the end, it all must have court approval. That's when it's finally admissible evidence. So no factual determination could possibly be made at this point. The Wayfarer parties still maintain that they're innocent, so these factual determinations will ultimately be determined one way or another. But at present, they're still pending main action. Another point I've taken issue with multiple times is that Lively and the amici who wrote all those ridiculous amicus briefs all contended that 47.1 must be imposed at the earliest possible stage of litigation, mentioning motions to dismiss. Was that correct? Well, if you keep in mind everything we just said about factual determinations and what it takes to get to that point, neither the statutory language nor its legislative history address dismissal before these claims are tried in the main action. So making a decision without these factual determinations is a misapplication of this law by its own standards. And so Ellyn basically says that Blake has erroneously demanded these remedies at an early stage of litigation, and that this law only works if it's proven that the claims were reasonable and not malicious. Since this hasn't been decided yet and can only be decided by a jury or an evidence-based ruling, and we're at a stage where there's no evidence, information is still coming in through discovery and depositions, it seems that Blake and the amici have got it wrong. These amici who presented their lengthy briefs also made this demand to the court. But is this the spirit of this law as it was written? Now Blake claims that it saves survivors. It irks me to my core when she calls herself a survivor. But the claim is that it protects them from a protracted or lengthy legal process. Now to make that claim, you have to be also making the claim that applying it will somehow shorten the duration of a lawsuit. Is that a possibility? No. That's all been set, with or without the ruling. And nowhere does the law itself say that it can be imposed before the harassment case is resolved. Applying the law now would take away the defendant's right to defend themselves at trial. This is a huge problem, and this is just one of the problems that makes it seem unconstitutional, because this takes away the defendant's Sixth Amendment right to a fair trial. And then she adds an excellent point that if Judge Lyman grants these damages at this point, where she's demanding them right now, what if a jury turns around then and doesn't find in her favor? What's he going to do about already having granted her these damages? And it's not mentioned here in this filing, but if he did grant these now, what would that tell a future jury? Wouldn't that appear to them that the judge has already found in Blake's favor? Wouldn't that have a huge impact on jury bias? And you better believe that Ezra and Gottlieb would be trumpeting this as a win, both now in the press and to the jury at trial. And what a miscarriage of justice that would be. And then one of the biggest points that gets repeated the most often is that no California court has explained how punitive or treble damages can be calculated without a baseline finding of actual compensatory damages by the trier of fact. Remember, treble damages are when you take the amount of actual damages calculated by the jury or by a judge and you triple them. These things are determined after guilt has been established. If a person is found guilty of these things, damages are totaled and then dealt to the defendant. How is he going to rule on treble damages of something that hasn't been decided is owed and hasn't been calculated? Like I said, we'll come back to this point a few more times. Her request to apply this has already been denied once. It was denied without prejudice, so that gave her the right to request it again. But when you have something denied and you're given a chance to bring it back to the court because it was denied without prejudice, you can't just bring the exact same complaint again to the court. The court has already denied those. You have to bring something new to the table that the judge can look at and say, oh, okay, this is a better argument than last time. Last time it was insufficient, but she's corrected her insufficiencies. And so I can grant it this time based on these reasons. But she hasn't done this. For example, she's left out the key issues of her own motive and intent. Why didn't she talk about that? That's stated clearly in the law that that has to be shown. Why didn't her team address it? Instead of addressing it, she recycles the full breadth of all of her allegations that we've heard over and over and over again. The judge already rules on all of those. And another problem with this repetition is that the bulk of the allegations have nothing to do with harassment, which is the only thing that 47.1 covers. The protected speech of her harassment and the damages are supposed to be for a retaliatory defamation case. So what do any of these things that she stated in her long and snotty filing? They have nothing to do with 47.1. For example, they talk about her arguing about a defamation claim against Ryan Reynolds and Leslie Sloan. Not only do those have nothing to do with her 47.1 claim, she misrepresents what the ruling was. She says that they were dismissed for failure to plead malice, sufficient evidence of a smear campaign, and strong evidence that the Wayfarer party spread negative stories about Lively. But that's not what the judge ruled. And so we find Ellyn reminding the court that none of that has anything to do with 47.1, and that it wasn't dismissed for those reasons. It wasn't a failure to prove malice. She didn't prove that she brought the claim with good intentions, but the ruling was based on her complaint being privileged. And that was not based on 47.1, but on California's litigation and fair report privileges. By ruling on those grounds, it became unnecessary to even reach the issue of malice. So this is an absolute misstatement. And though Blake's rehashing of her allegations was exhaustive, as Ellyn brings out, it remains short on the relevant factual issues and devoid of legal authority. It was long, it was full of complaints, most of them not relevant, and no legal authority to support what they were asking the court to do. So how do you justify giving these damages? You can't. Then we have a list of 5 things that she says are reasons that this motion should be denied. The first one is extraterritorial application. We're going to dive into that in a moment, but basically what we talked about before, applying California's civil code and statutes outside of California. The second point was that she didn't present any new laws or facts for the judge to reconsider. If it's all the same things he already denied, it's a waste of paper. The third point, no trier of fact has found based on admissible evidence that the claims were asserted without malice and with a reasonable basis. Number 4, she also fails to show, and no trier of fact has found, clear and convincing evidence to prove the malice that's required to be proven in order to be awarded punitive damages. These are all the things that should have been in her motion, but instead it was a long, whiny list of complaints. And another point we've talked about here, she hasn't proven and no trier of fact has found the actual compensatory damages required as a basis to calculate treble or punitive damages. Proving malice is very, very difficult. We've talked about this, how difficult it's going to be for her to claim damages. She was paid for her work on the film. There's no damage there. She wasn't fired. There's no damage there. She didn't have regular enough work before the film to base a claim of her not being able to find work after. Not only that, she's bragged about a new film that she's going to produce and star in just last month. She still has the same movies listed in her production company that she's had sitting there for years. So where's the loss? Her hair care was brand new. She has no previous sales to compare to claim loss. Could she even use hair care since it has nothing to do with the claim? She wasn't working selling hair care when she alleges these things happened. So can she even bring those in? But even if she could, what previous sales could she compare them to? And also last month, she's continued to brag about her sales. So it's entirely possible that this lawsuit has made more people aware of her hair care and possibly even boosted her sales. I dare say a lot more people know who she is because of this lawsuit. A lot of the younger generation had no idea who she was, other than Ryan's wife. Also, when it comes to her damages, she dropped her emotional distress claims because she was told she had to provide medical records. Records she either didn't want to share or simply doesn't even have. So what damages, Blake? If you have no reportable damages, even if you multiply that times 3, it's still $0 damages. And now we move into the juicy part about the constitutional concerns. Now, another claim that Blake has made in her filings is that 47.1 was intended to protect victims from the litigation itself. They've just taken this new law that's never been used in court, and because of that, they've been able to make all of these wild claims about how it's supposed to be used. The truth is, there is no precedent for it, so no one knows how it's supposed to be used. That's going to make deciding how it's going to be used a huge task. Now, the first constitutional concern that gets raised is the First Amendment. Clearly says, Congress shall make no law respecting, we'll skip down to the important part, the right of the people to petition the government for a redress of grievances. It is our First Amendment right to petition the government. And that opening, Congress shall make no law that does any of these things. Things like prohibiting freedom of religion or abridging the freedom of speech, freedom of the press. It is not within the power of Congress to do this. So what do you do with a law that stomps on the First Amendment? Another doctrine that's supported by the strength of the First Amendment is the Noerre-Pennington doctrine. This came out of an antitrust case, but since then has had a much broader application. Basically, because you have the right to petition the government, you cannot be punished for doing so. And so by definition, we have this new law that does impose a statutory penalty for unsuccessfully bringing certain types of lawsuits, even if those lawsuits were done in good faith. It takes away a defendant's right to petition the government for defamation. So 2 things here. It takes away the First Amendment right to petition the government, and it seeks to revoke this immunity that's already been decided that we all have. This doctrine was born of 2 Supreme Court cases. As I said, it was about antitrust. It was about lobbying lawmakers. The first one was the Eastern Railroad President's Conference versus Nowhere Motor Freight. And the second one was United Mine Workers versus Pennington, thus the name. Because these were Supreme Court cases, as we know, those are the strongest case law that can be used, and they set legal precedents. So as this doctrine was being applied to cases, it began to broaden. It went beyond the realm of lobbying and straight to the heart of the First Amendment's right to petition the courts through litigation. This was done through another case, the California Motor Transport Company versus Trucking Unlimited in 1972, that says the right of access to the courts is indeed but one aspect of the right of petition. So further defining this First Amendment right to petition the court. But the First Amendment is not the only one that 47.1 tramples on. Applying 47.1 at the pleading stage risks violating due process because they're dismissing actions before the accrual of discovery or factual development. This is a special problem when the issue is malice, because malice is really difficult to prove. It requires lots of discovery. This kind of proof is unavailable before depositions and document production. So dismissing defamation actions on the pleadings because plaintiffs fail to allege malice with specificity might actually effectively deny redress without a real opportunity to present evidence. And this kind of already happened to Wayfarer. Their claims were dismissed so early, before they had a chance to receive much discovery at all. How did the court know what kind of proof they could come up with? And that's the very heart of due process. This clause was added to safeguard from arbitrary denial of life, liberty, or property by the government outside the sanction of law. So the Supreme Court says this covers 4 different protections. The very first one being court proceedings, civil and criminal. Due process is mentioned in the Fifth Amendment. We see criminal cases have to begin with an indictment of a grand jury. We see double jeopardy ruled out. We see the part that the Fifth Amendment is the most famous for. You don't have to be a witness against yourself. You can plead the Fifth. And then the point we're talking about today, not to be deprived of life, liberty, or property without due process of law. And this is repeated in the 14th Amendment. Again, that's how important it is. So we have it in the First, we have it in the Fifth, we have it in the 14th. And this one adds, after repeating the same words we just read, nor deny to any person within its jurisdiction the equal protection of the laws. Is this equal when you take away someone's complete right to defend themselves just because another person has accused them of something? There is nothing equal about 47.1. What does due process mandate then? A chance to be pled and be heard. That means you have the right to collect discovery, and you have a right to a trial where factual disputes will be heard. And it's important to note that the Bill of Rights itself is, of course, the first 10 amendments, and so, of course, it's in there with the First and Fifth Amendment. These are the very foundations of our law. How is a new law coming along and trampling over this thing that's mentioned all of these times in the amendments? And that's why it's so shocking to me, and a lot of you, that this law was ever allowed to pass. I think it was the timing. I think people didn't want to speak out against a law like that. They brought victims with them. Those victims told their stories, and nobody wants to appear to be misogynistic or to be on the wrong side of a law like this. So I showed you guys the videos when they kept bringing these and trying to get it passed. But I strongly feel that as it's being applied in courts, it will be appealed to higher courts and eventually either changed or done away with. I don't see it, as it is written today, as being built to last. Now, this case isn't in the motion. This is my own finding, but I want to add it in here because this is also a U.S. Supreme Court case, and it lets us know the Supreme Court's thoughts. It's Logan versus Zimmerman Brush Company. Logan filed a discrimination claim under Illinois law. The state's agency failed to schedule a hearing within the statutory deadline, so as a result, his claim was automatically dismissed. It wasn't his fault. It was accepted by the Supreme Court, and they held that access to courts is a protected liberty interest, and that procedural rules and mistakes by the state cannot arbitrarily block someone's right to seek redress. They stated, the court has recognized that certain interests are so fundamental that the state may not constitutionally eliminate them without affording the affected individuals an opportunity to be heard. What does 47.1 do in the way that Blake's trying to have it applied? It completely blocks the opportunity for the other person to be heard. The Supreme Court says this is not constitutional. The right to use the courts is one such interest. The Due Process Clause grants every person the right to be heard at a meaningful time and in a meaningful manner. A person's claim to a legal remedy cannot be terminated by the state, even the state of California, without notice and an opportunity to be heard, especially when the termination results from arbitrary procedural rules rather than the merits of the case. 47.1 is all about procedure and not merits of the case, the way that Blake is asking for it to be applied. Now, in the law is the exception that malice has to be proven, but the way the people who claim to have had a part in the writing of and the passing of this law, who wrote these amicus briefs, they stated the same thing as Blake, that the case basically gets dismissed right off the bat before any merits have a chance to be proven. That's not the belief of the U.S. Supreme Court, based on things like the amendments to the Constitution. In addition to federal law, California, the only state so far that has 47.1 put in place, also has its own absolute litigation privilege. It protects statements made in judicial proceedings, any proceeding that's authorized by law, even if they're considered malicious. And that's California Civil Code 47B, so it's in the same section. But this right is absolute. So, if a defamation claim is brought to the court, it's a judicial proceeding. So how can you reconcile these two statutes in the same section of law? They're at war with each other. And Ellyn does a splendid job of bringing in so many case law citations. And this is the perfect quote at the bottom from Dickinson versus Cosby. The privilege is absolute and applies to all publications, irrespective of their maliciousness. So how can this new statute undermine this long-standing statute that's already been in place in California? There's a lot to be worked out with this law. We see again all of these cases that she cites all support this. Notice the last one at the top. It's from the judge's own ruling. He's not only going to have to rule against other federal courts, which he's done. He's not only going to have to rule against rulings from his own circuit, which he's done. He's not just going to have to rule against himself, which he's done. He's going to have to rule against himself in this very case in order to rule in Blake's favor. And this protection even extends outside the courtroom on all torts except malicious prosecution. And if anyone is going to have a shot at a malicious prosecution claim, when this is all said and done, it's going to be the Wayfarer party, not Blake. We see this immunity that 47B supplies is all about freedom of access to the courts to secure and defend their rights. Quoting one of these cases, it is desirable to create an absolute privilege, not because we desire to protect the shady practitioner, but because we do not want the honest one to have to be concerned with subsequent derivative actions. All of these protections were put in place a long time ago and have been carefully protected all of this time, and this one law wants to bring it all down. And it's just such a wild notion to me to deprive someone of the ability to clear their name, to take away the right to collect and present evidence, and to short-circuit the legal process before facts can even be examined. And by its own wording, again, malice is the caveat. How do you discover and prove malice if you didn't get a chance to complete the legal process? You can't. And then from this point, she just unleashes here how weak Blake's arguments are. She just piles on all the ways that Blake's demands for this application are lacking. There are so many questions that are left unanswered here, and the judge who's going to rule on something like this, to be frank, isn't going to be pleased by all of the work that it's going to entail. He'll be even less pleased because the attorneys who filed this haven't done any of the work to help him to provide a legal basis for what they're asking for. That's the whole point of case law. It's there to show the judge what decisions have been made in the past compared to what you're asking him for to help him make his decision. Blake hasn't addressed any of this. All she did was list a bunch of whiny complaints. That doesn't help the judge take on this monumental task of being the first judge to rule on a law, a brand new law that's not even from his state. There are so many things to take into consideration here. We've covered several amendments. We've covered a doctrine from the Supreme Court. We've covered other case law. This is potentially a several months long process because we know how busy federal judges' schedules are. And because his ruling, if he rules on this, will be examined and taken apart whenever and wherever this rule is brought up, he's going to have to get the research just right. And now we get to more amendments, 8th Amendment and the 14th Amendment. These both point to the need for constitutional ceiling or cap of fines. Now 47.1 just automatically hands these exorbitant fees, just for the asking. But she says Blake has failed completely to even explain how it applies to her. The defamation was dismissed at the pleading stage. Because of that, There were no factual issues of whether the claims were asserted with malice and without a reasonable basis. These are issues of fact that are supposed to be decided by a jury. She didn't address that. She mentions these punitive damages being particularly troubling. Why? Because California has a long-standing rule that there's no right to punitive damages. So we have this statute at war with yet another long-standing law in the state. How did this pass? I don't know. So what does California do? For punitive damages in California, it requires clear and convincing evidence of malice. Again, we covered how hard it is to prove malice by going through the jury instructions. It is no easy task. It's based on admissible evidence, and it's determined by a jury. How is 47.1 going to overcome this California law? So even when a jury finds punitive damages are warranted, this is where, actually I think it's the 8th Amendment, prohibits excessive penalties and limits damages. And so that brings questions. How does 47.1 just allow for these damages to be awarded as a matter of right, not have to be proven? How are these damages calculated if there hasn't been an award of actual damages? Damages are decided after a jury delivers a verdict or a judge makes a decision in summary judgment. Neither of those things have happened, so damages cannot be determined. So how can they be given? Justin's defamation claim was dismissed on a motion to dismiss, so none of this was answered or addressed by any jury or any judge. Blake failed to offer a remedy to this or even address this in her long list of whiny complaints. What else did she not address? Any authority for how the court can calculate any kind of punitive or treble damage without an award of compensatory damages. You can't math without numbers. I'm guessing Gottlieb was really embarrassed by seeing all the ways his angry little filing failed. She continues, the plethora of serious constitutional and other legal questions have not been addressed by any California court, raising the preliminary question of whether this court, as a matter of first impression, should apply 47.1 to impose the draconian remedies of attorney's fees, treble damages, and punitive damages, without any answer to or even guidance on these critical questions and concerns. So basically, we've got a whole lot of problems here. The big kind, constitutional problems, doctrine problems, that these things don't jibe with Supreme Court rulings. And there's no guidance, there's no way to do the math for the judge to make his decision based on. And I love this little line she puts in here. It may have been for some or all of these reasons that the court has already declined to award Lively the relief she seeks under section 47.1. And if the judge hadn't thought of all this, you know he's thinking of it now when faced with making this decision. They remind us that the judge specifically stated that he did not rule on 47.1. And so they're saying, Blake, if you want him to rule on this, you have to fully brief the impact of this opinion. And you have to address all of these issues. You can't just deliver a repeat of your request that was already denied and ignore all of this important stuff. She says again that basically Blake just filled her motion with an extensive exposition of the facts asserted in prior pleadings. She didn't cite any new facts, she didn't cite any new law, she didn't show how she had a reasonable basis for her claims, and she didn't address whether her claims were asserted with malice. And I love this part. Simply put, nothing has changed since the order, and Lively and this renewed motion appears to be nothing more than an improper request for reconsideration, seemingly contrived as a thinly veiled effort to poison public perception and the potential jury pool. At best, the motion is premature. And that's so true, because it's missing all of these foundational aspects. It's a waste of the court's time. Things weren't looking well, so some weird stories have been popping up in the press, and this motion came up. But it's not well written. It's missing the key factors that it needs to have, the most important things that it needs to consider. And I love the way it says, the court should decline her invitation to interpret 47.1 as an issue of first impression in the dearth of any guidance from a California court, and impose heavy-handed penalties which would require this court to make premature factual determinations. Now, I found a case in Tennessee that had a similar sort of situation, because historically there can be lots of tension between a federal court and a state court if they don't respect each other. Federal courts do like to leave state sovereignty in state court, but sometimes, since they're applying a state law in their federal court, that can get messy. And this is one of those situations, because in order to honor the state's sovereignty, there has to be an actual state law put in place that they can follow. As in this case, there is this state statute 47.1, but it hasn't been put to practice in the state of California, so there's nothing to use as a guide to make this determination in federal court. So there was a case in Tennessee, Lindenberg versus Jackson National Life Insurance, but it was messy. If you saw my video about 47.1 that I did a couple of months ago, I described the differences between state and federal, how federal determines the procedure and state determines the substantive. I went through the history of how this all came to be. We talked about the Erie Doctrine and making decisions that put a stop to people sort of shopping which court will be more favorable to their case. Every now and then something will come up that will challenge this idea, as it did in this case. So Lindenberg was the beneficiary of a life insurance policy, and Jackson was the insurer. They were delaying and resisting paying out the benefit, and so Lindenberg sued them. This took place in Tennessee. In addition to the policy proceeds, she also asked for punitive damages and attorney's fees. What the problem became was whether Tennessee law allowed both punitive damages and bad faith statutory damages for the same insurance misconduct. Tennessee state law provided for a 25% penalty if an insurer acted in bad faith and refused to pay. The insurance company said, "This is your only remedy. You can't also get punitive damages." This was a diversity case, and so it was being heard in federal court. It was applying Tennessee state law. But since this had never been decided in state court, if the federal court was going to make a ruling, it was going to be first impression, creating a new state law. They don't like to do that. So the jury awarded $350,000 in contract damages. Then they applied statutory damages, which in Tennessee are called bad faith, in the amount of $87,500, and then applied $3 million in punitive damages. Now, the district court ruled that this was too much. They reduced the award to $700,000 by applying Tennessee's statutory cap on punitive damages. Then they refused to award fees under the bad faith statute. And so Lindenberg filed an appeal. This is the Sixth Circuit, and they challenged this reduction and this punitive cap. The defendant cross-appealed, and it ended up in the Tennessee Supreme Court. The big question that was before them was whether Tennessee's statutory punitive damages cap violates the Tennessee Constitution's jury trial right. The case sat there for 7 months, with the Tennessee Supreme Court declining to answer the question and not giving a ruling. The case then returned to the Sixth Circuit Appeals unresolved. So when it came back there, they decided that the statutory cap violates the Tennessee Constitution's right to trial by jury and reinstated the full $3 million punitive award. They held that the bad faith statute does allow recovery of attorney's fees, remanding for consideration. Jackson appealed again. The Sixth Circuit denied it, and an appeal was made to the U.S. Supreme Court, who did not take it up. But what it left was tension, because a decision made by the federal court differed from the state court. And it remains unsettled today, and there is a gap in decisions made in federal court from state court, which is what courts do not like to have. It's a source of tension, and it's unfair. So the Sixth Circuit's decision stands in federal court, but the state court side of things is still unsettled. But it brings the point that federal courts do not want to invent state law, and that when it's attempted, you can end up with these situations. A much different outcome depending on what court you're in. And so this is a possibility that Judge Lyman faces if he chooses to rule on 47.1. Now, these tensions between federal and state court have brought about different doctrines meant to try to reduce these frictions. One of them is called the Pullman abstention. And what this does is so that when a federal court is at a loss about a decision, when they're having to make a decision and there is no state law decision on it, what they can choose to do is apply this doctrine, send it to the state, like Tennessee tried to do, and have them decide. This is time-consuming, it's messy, and it's not in the best interest of judicial economy or speedy trials. So it comes, as many of these things do, with the three-pronged determination of what sort of cases qualify for this doctrine to be put in place. In speaking to people, I've had different opinions put on whether or not this case passes those prongs to be passed for the state to make the decision. Frankly, I would hate to see that happen because it would be put in California's hands. Another option would be for Judge Lyman to simply say, "I'm not going to rule on this." But the three prongs are uncertain or ambiguous state law, which 47.1 does fall under that. Potential to moot or alter constitutional inquiry. This is a possibility. We're talking about how it tramples on some constitutional rights, the importance of avoiding unnecessary federal constitutional rulings. So it would have to substantially further federalism concerns and judicial efficiency. It may qualify simply because of these First Amendment and due process rights. Some of the questions that have used this doctrine have been specifically California anti-SLAPP statutes. But that was all within California. We know the Second Circuit does not recognize anti-SLAPP. But either way, if Judge Lyman is going to take on 47.1, he has a substantial amount of research he's going to have to do. I don't think he's going to want to do it. It's a lot. It opens him up to appeals. It opens him up to criticism. It's not a small thing. It's also going to cause delay. If he were, for example, to use this doctrine, that's going to cause months and months of delay, no doubt. Personally, I think he's simply going to say, I'm a New York federal judge. I don't have to recognize this, and so I'm not going to. Now back to B, this extraterritorial problem. As it says, and this is a problem I've mentioned multiple times here, Blake's a resident of New York. She says this conduct happened during filming, which was in New Jersey. And she's brilliant with case law again, citing case after case where they basically say, hey, if California meant for this to extend beyond California, they know how to make a statute that gives very clear indication of that. But this one has none. So obviously it was not meant to extend beyond California's borders. This Ward versus United Airlines very clearly, when a statute gives no clear indication of an extraterritorial application, it has none. Basically, if it's intended to apply beyond the state, it would say so. And these quotes are just absolutely brilliant. And what I've been saying all along, FEHA should not be construed to apply to non-residents employed outside the state. And when the tortious conduct did not occur in California, an extraterritorial application of FEHA would raise serious constitutional concerns. The Commerce Clause precludes the application of a state statute to commerce that takes place wholly outside of the state's borders, whether or not the commerce has effects within the state. And she continues firing away at all the ways that Blake's motion failed, bringing up these amicus briefs again, how they quoted extensively from the legislative history, but never pointed to express language or any portion of that legislative history that even hints at an intent that it would apply to anywhere outside of California. Nowhere in that history does it indicate, there's just no expression that it was intended for that. And so presumption applies in full force that Lively, as a non-resident of California, cannot invoke it for conduct occurring outside of California. It's a California state law. It doesn't affect California. It didn't happen in California. She doesn't live in California, so she has no effects felt in California. She filed the CRD complaint in California, probably specifically to use this. Now that we know Ezra was involved with these organizations that were behind it, she was fully aware of this law and probably wanted to be one of the first ones to have it apply. But filing the CRD complaint in California is not enough to make it so. So they're saying if she's going to make this motion work, she has to establish a substantial connection between the legally relevant conduct in California, specifically the location of where the alleged wrongful conduct occurred. She can't make that happen because she already said that after she had that 17-point return to production, that no further bad conduct happened. So all of her allegations supposedly happened in Jersey in May. Any filming that took place at the very end that was in California was long after that, at a time that she's on paper already declared that nothing happened. She also quotes case law that destroys Blake's contention that because Wayfair's place of business is California, that causes a contractual choice of law provision. But alas, it doesn't. And I read this line, a formulaic conclusory blanket recitation of ratification is insufficient to overcome the presumption, absent facts sufficient to establish a factual nexus between the defendant's California-based activities and the allegedly wrongful conduct. And I read that as Blake's word salad is insufficient to overcome this presumption. And that became the inspiration for this thumbnail, with Blake presenting her word salad to the court and Queen Ellyn looking at her like she's lost her mind. And her line comes up later. And in this one case, the plaintiff actually was a California resident, but she worked in Nevada and her employment was terminated in Nevada. So even though she was a Californian, even that was insufficient to defeat the presumption against extraterritorial application of California law. The wrong did not happen in California, even though she was from California. So if that didn't hold up, what chance does Blake have? This is all kind of summary, so it's repeating a lot of stuff we've already talked about. And then the last question, if damages have not been decided by a jury and that Blake deserves compensatory damages, how are they calculated? 47.1, FEHA, or even the federal Title VII, none of them provide for presumed damages. So in order to get punitive damages, there has to be an award of actual damages. There hasn't been one. Liability hasn't been found. And this was the other inspiration for the thumbnail. Ellyn saying, put another way, what exactly would the court be troubling? Indeed, there has to be liability found, damages calculated, and then tripled. This law needs fixed. I think it came from a good place, but it's just got way too many problems associated with it. And then we have this interesting little filing. Document 800 is her declaration where she states 3 different parties that she deposed. One of them was Blake's makeup artist. Now remember, these people were supposed to have barged into her trailer when she was topless, having makeup removed. I think it stands to reason that the makeup that was probably being removed was that fake tattoo on her collarbone, because we didn't really see anything else on her body in the movie. There would be no reason for her to be absolutely topless, to have something removed from her collarbone. So this person's testimony is probably very important. The bits that she shares are sealed for now. This makes me really, really want to see them. The second person is Warren Zavala, who's Blake's talent agent at WME. And then there's Danny Greenberg, who was Justin's talent agent. We know Ryan was running to WME, where his ride or die is a top guy there, demanding that they drop Justin and calling him an S-predator. So we're starting to get some glimpses that Wayfarer's probably got an excellent case that they've been super quiet about. And I think that's showing up in all of this nonsense that's happening in the press right now. This whole big thing about Taylor Swift. Will she stand up for what's right? Will she stand up to Blake? I guess we have to wait and see.